This episode of Off the Cuff is brought to you by Weaver Simmons, and we're very pleased to bring it to you. I hope you enjoy it.
Welcome back to Off the Cuff. Now, I'm Darren Chohan, and usually after this point you would hear, and I'm Mr. Butler, or Matt Butler. Well, unfortunately, as you can see if you're watching the YouTube video or hear the crickets and the silence, I no longer have my co-host. In a strange turn of events, he decided to leave me, and he's now accepted a position elsewhere. I wish him the best, of course. I'm just a little bit sad because this used to be our time together and our special fun, adventure that we got to go on once in a while and record a show together. But nonetheless, as they say in showbiz, the show must go on. So here I am by myself today, which most of you are probably disappointed about, but there is a plan going forward, and it's probably going to turn into a interview series of sorts, and we're going to have people on the show and mix it up a little bit and try to keep this thing going with the same speed it was in the past when we first started, and hopefully we can continue moving this along. Now, to get us back in the swing of things, and I'm not sure if you guys follow us on social media, which you should, we have an Off the Cuff Instagram account, which it'll be in the links below, and we'll put it up on the screen. You should go follow us, because what the plan is now is to use our Instagram account to generate audience questions and to have you guys interact with the show so that we can give more legal information that's tailored to the viewers, listeners, and whoever's out there that wants to know something that's, maybe off the cuff. Now, we ran this story, which was called an Ask Me Anything. And this was my plan to get back in the room and see how much engagement we had and what people really wanted to know, because ultimately our show is to provide the listeners and the viewers with something tangible that they can leave after listening. They have some more information on. So I thought, why not? Let's do an AMA. And I was actually surprised at the value and the volume of engagement we had with our stories. So, I'm going to go through some questions today. Some of the questions won't make it on the show. If they don't make it on the show, don't fret, because my also plan is to release shorts with answers to some of your questions. So don't get discouraged if you don't necessarily have your question answered today. Know that we've read them all, and the team behind the scenes is going to work to get more content out to you guys. So one question came in, which I thought was quite funny, and it was from another lawyer. And I thought I'd start off with some levity and some light mood and light humor. The question I got was, what if law isn't for me? And I laughed and I said, well, how do you answer that, right? And I think if you're a lawyer in that position and you're wondering, did I make the right choice? You don't necessarily have to use your law degree to be a lawyer. There are many other jobs out there that lawyers do behind the scenes that are not necessarily licensed lawyers. You have jobs ranging from, you could do investigations at a university. You could be in-house counsel at a bank. You could be in-house counsel at a regular firm, not necessarily practicing law, but what you're doing is you're advising those people on what you interpret the law to be at that time and in the current context. And effectively, you don't have any clients. Your client is the business that you work for. And you can use your law degree in that way. I have friends from law school who went on to use their law degree and open a brewery, and to get through all the red tape in starting a brewery. Their law degree was useful in negotiating terms with the municipality, with the government, getting the liquor licensing, getting their permits to do what they do. So if law isn't for you, think about something outside the box. Maybe that means that you should work in a different field, but you've got yourself to a point where you have a law degree. It's going to be valuable in some context, and you can use it. Now, there are also other people who have a law degree and they are musicians, or they have a law degree and they work in sports betting. So the door is never shut to you with a law degree. And I think for those of you who are thinking about pursuing a law degree, the idea that you're trapped in the classic firm setting representing clients in a certain area of law is the only way to use a law degree is not really the reality. So I would encourage all of you guys who are listening out there and watching, if you're thinking about a career in law, in quotes, think about what the skills you learn as a lawyer going to law school and perhaps if you do end up practicing for a little bit, how those can translate into other areas of expertise. And so it's not a waste. You know, I enjoy practicing law in the traditional fashion, and the idea that you just need to use a law degree to practice law is, I think, one of those things that is an old way of thinking, especially in today's day and age with AI, with the different technology that's available. You can use it to even work for software companies to help develop software for lawyers, which is actually something I was involved in and have been involved in. It's really, really interesting. So that's my TED talk on being a lawyer. You don't have to use your law degree to practice law. You can use it to do a lot of other things. But if law isn't for you, think about other ways that you can do it. Another interesting question came in here about, and I'm going to jump a little bit over the place in areas of law, just because, you know, in my practice, I see these questions come up a lot, and it's a question that does actually come up quite frequently in just regular life. We got a question asking, when you're traveling internationally with children, and you are either married or separated, and you are wanting to go outside the country, do you need a letter from a lawyer? And so the simple answer is you don't need a travel authorization, but it's recommended to have one because for two reasons. One, if you don't have one, there is a risk that you won't be admitted to the country that you're going to. And number two, there's a risk that if something happens in the country, so if you're let in, but something happens in that country, and you don't have a travel authorization, you may be subject to having to deal with the authorities in that country to prove that, in fact, you are the parent of those children. And so standard practice, what we advise all of our clients to do is obtain a notarized travel form. There is one available on the government website. We'll throw the link down for people who are listening in the description and watching. You can fill that form out, and then you take it to any lawyer who can do a notary for you, and you get them to notarize it, and then you have your ex-spouse or your current spouse sign that letter. And that enables you to show this proof at the border, and 95% of the time, nobody's going to ask you for this. But if you don't have it, you know Murphy's Law says that you'll probably need it. So that actually brings up also a question we get a lot in our practice about notaries versus commissioners. So you'll see a lot of documents and a lot of professional designations that need or require a document to be commissioned by somebody or notarized by somebody. And people don't know what the difference is and why you need one or the other. Simply speaking, a commissioner is somebody who can commission a document to prove the truth of those those documents or document, and that they've verified and seen a true copy of the person's identity, and also verified that the document is a copy of what the person is tendering as a true copy. The commissioning is only valid in the province of Ontario. And of course, I'm going to talk about Ontario because that's where we are. And so it's only valid for our province because the commissioner is appointed by a provincial statute. But a notary is somebody who is a lawyer who obtains a notarial seal. And the notary seal is applicable outside the province. So this is why you need a travel authorization that's notarized, not commissioned, because your commissioner designation is only recognized in the province in which it was issued, whereas your notary seal is recognized worldwide. And so that is the true difference between the two. So that was something that we get a question about a lot as lawyers, and people actually just walk into the office and say, hey, I need this commissioned. But upon review of the document and where and the purpose of the document, you actually need it notarized. And so now by knowing that, you'll know what you need. The other piece of that is commissioners can be people that are not lawyers. So for example, the registrars at courthouses can commission. So if you need a document commissioned, you can go to the courthouse and they can commission documents for you. And I think there is a fee for them to do that. But there's lots of individuals, I believe MP's offices have commissioners on staff. So that's why it's valid for, I should say MPP for the province. So that's a long-winded way of saying now you know what a commissioner versus a notary is. Jury duty. Do you have to do it? That's another question that is burning in a lot of people's minds, because I know for a fact that when somebody gets that letter from the court and you've been called to be on a jury, instant panic ensues, literal panic. And you're like, well, I don't want to do this. How do I get out of it? Well, sorry, you can't. Unless you're a lawyer or an essential service, you can get out of it in that way. But there is a way to explain yourself when you actually get to the courthouse and are at the stage where they're calling you up to say why you think you cannot do jury duty. Now, the jury process is foreign to a lot of people, and I'll explain to you how a jury is selected. And then we'll take a little break because I've been talking for a while. But jury selection in a civil case is only 6 people, and jury selection in a criminal case is 12. Now, when they do the call for jury duty, they send out somewhere in the neighborhood of 200 notices to random members of the public, and they'll ask you to appear in court on a certain day. So all of you have to go. You have to fill out a form and send it back if you are one of the members of the essential services, like nurses, I believe, are one, firefighters, paramedics, lawyers. So if you are a designated class member of one of the people that are excluded, you can fill in the form and then you don't have to attend. But if you are not one of those people, but you, for example, have a dying relative that needs your care, or if you're caring for young children, etc., you still actually have to show up to court on that day and arrange for childcare and arrange your life to be there. But you'll be in a room of 200 people with a randomly assigned number, and they'll choose random numbers out of a box and you'll have to go up. So if your number doesn't get selected that day and they choose their panel of 6 or 12, then you're free to go. But if your number does get chosen, you get up to the dais, and then one lawyer will say they want you or not want you, and then the other lawyer will say they want you or not want you. At that stage, you have a chance to explain yourself as to why you think you shouldn't be on a jury. So when you boil it down, you get called for jury duty, but you probably won't get the call when you're there. So long story short, show up, explain yourself, and the lawyers may not even want you. And with that, we'll take a break, and we'll get back into a few more questions afterwards. Make sure to like, follow, and subscribe. And we're back. While we were on break, I had a thought, which is rare, but I was talking about jury duty before we left, and I just wanted to give a little update as my brain was turning that Now, criminal juries, they took away the lawyer's right to reject you. So now it's just you and basically God between you, whether you get selected or not. So you better have a good excuse if you don't want to be on that jury. Anyways, the next question that we get a lot and we received on our little Ask Me Anything series was, what is the difference between joint tenancy and tenants in common? And some of you listening to this or watching probably have no idea what those words mean, and that's okay. But if you've ever bought a house and you've ever met with a lawyer, a real estate lawyer, they'll throw these words at you. And it's not embarrassing to be like, hey, can you explain that to me? Now, sometimes they'll be like, yeah, sure, and go into the whole details with you. Or sometimes they'll just say, you just want to be joint tenants. Or you should just do this as tenants in common. And you probably are looking at them being like, okay, don't do that. Now you're going to know the difference between joint tenants and tenants in common. When you buy a property as a joint tenant, what that means is that you're purchasing this property with another individual or individuals where it's a right of survivorship. What that means is that you have equal stake in this property, and if somebody passes away, that property will transfer to the remainder person on title or the remainder people on title. That's the basic description of what a joint tenancy is. And I'll get into what that might implicate for some of you who are thinking about getting divorced, hopefully not, or own a property with your spouse. But the other version is tenants in common. Tenants in common is where you can designate an ownership share per party that's on title. So we see this frequently when perhaps friends purchase properties together or investors purchase properties. They'll go on title with the share that they paid for the property. So if you have somebody who contributed 70% of the money towards this property, they want to retain that 70% share. They don't want to share the distribution of the proceeds of ultimate sale equally. They want to designate a distribution. And so that also gets into if there is a death and there's the property's held by way of tenants in common, in your will, which everyone should have, and we're going to get into in a few minutes, you can designate how to treat that share, and it has no bearing on what the other party's share is. And so if you are a 70% owner in a property and you designate that you want to leave that 70% share to your child or somebody else, then that person on your death will step into the place of you on title. And that person will retain the 70% share. Different, of course, and if you compare that to the joint tenancy situation I just talked about, if you die as a joint tenant, you cannot will that share to anybody. It will automatically transfer by way of survivorship to the other person on title. And so you have to watch for that. So next time when you're purchasing a property and your lawyer tells you, hey, you can be joint tenant or tenant in common, now you'll be a little bit more informed. It matters, and I said earlier that if you're looking at it in the context of a marriage or a marital property, joint tenancy, most spouses will purchase properties together, and they will go on title together as joint tenants. Ultimately, in the event that the parties do separate and that property has to be sold, and the caveat is that this property is the matrimonial home, which is the home they lived in during the marriage, that joint tenancy will operate to divide the distribution of the proceeds on a 50% basis on the ultimate balance sheet when you're trying to figure out the equalization payment. And we've talked on this show a lot about the misconceptions of divorce and how everything is split 50-50. Don't get into that trap. It's simply that equal shares on a joint tenancy will be allocated to each party, but not necessarily split equally. But if it is the matrimonial home and only one of the spouses is on title, it's treated like a joint tenancy. You can think of it that way. Apart from the right of survivorship, it is mostly treated the same from a distribution standpoint. So two parties, one owns the house, they live in it as a matrimonial home. If there is a separation, each party is allocated again 50% of the equity that's in that property to be then distributed based on the equalization calculation at the end of the day. So if you're going through that situation, I mean, of course, come see us, your lawyer. We can help you with all of that. But that's kind of the basics on joint tenancy and tenants in common and what you should be aware of when you're purchasing a property. Another question that we frequently get and in relation to properties, of course, is what about the will? Should I have a will? We had lots of questions that came in from our viewers and listeners about what is probate? What is a will? What is probate tax? How do I administer an estate when there is a will? How do I administer an estate when there isn't a will? Talk to your lawyer and watch the episode in our first season because that was a good one. We got a question about child support, and this is a quick one. Is child support taxable? And the answer is no. It's not taxable. So if you are the child support payor, you cannot deduct it from your income as a taxable deduction. And if you are the child support recipient, you can rejoice because it's tax-free money that you can use, hopefully, for the benefit of your children and not on a vacation to Mexico. But if your children happen to go with you, then maybe you can justify it. I don't know. In any event, child support, not taxable. Enjoy the money. Spousal support, on the other hand, is tax deductible. And a lot of people don't know this. And I'll tell you a little trick about spousal support. So if you're the spousal support payor and you're like, man, I have to pay $2,000 a month in spousal support. I got to pay another $1,000 in child support. I may as well go live in the trailer in my parents' backyard. I can't afford this anymore. Probably mostly true, but the spousal support portion of what you're paying your ex-spouse is tax deductible. So you can, in two ways, receive relief from that. And I actually just did a calculation today on a spousal support amount, and you'll be surprised to know that this was a $2,200 spousal support payment, but the tax benefit, the tax deduction, makes it only $1,300 as a net payment to your ex-spouse. So there is a significant tax benefit, and it also depends on what tax bracket you're in. But it can be make a big impact because there's a big difference between $2,200 a month out versus $1,300 a month out. And if you're really strapped for cash, and I'll put this link in the description below, but you can fill out a form with your employer where they deduct less tax off your pay to account for the amount of spousal support you're paying so that you have more cash flow up front, but you'll have a smaller refund at the end of the year. And then the other way to do it is to get that big refund at the end of the year, but pay your regular income tax during the course of the calendar year. So that's my little tip and trick to you. If you are paying spousal support, you may want to investigate filling out this form to increase your cash flow a little bit so you can get a less of a payroll deduction on your income taxes. And I think the last question that I'll answer, which was a really fun one, and I'm going to leave it on this because this is the juicy one that I was waiting to do. We got a question, and I really hope this isn't the case for the person that asked the question. And of course, all the questions are anonymous, so we're not going to out anybody here. But this person says, I discovered that my late husband had a mistress for 20 years. Is she entitled to his estate? I read that and immediately thought, oh, that's a bad situation. And the answer, sadly, is probably. But not in the traditional way you're going to think. So that person, the mistress, we'll call him or her or them, that person can make a claim for support against the estate. If they truly were in a relationship outside of the marriage and your current spouse who was seeing this person actually supported them as well, they can make a claim against the person's estate for what we call dependence relief. And that's effectively a fancy way of saying it's like spousal support in death. And so depending on the nature of the relationship, the length of the relationship, and how serious it was, that that estate may be on the hook to support that other party, even though it was unknown to the spouse. What makes it really awkward is when the spouse is the executor of the will and they're dealing with paying support to the mistress. It's going to get ugly. But long story short, there is a claim. So if that is you, and if you are listening, you should probably speak to a lawyer to deal with that. The other tip to note, if you are making a support claim against somebody who has passed away, is that there are certain time limits that you need to make the applications for. And so you should watch out for those. And one of the most important ones is 6 months after death. If somebody has passed away, you have 6 months to bring forward a claim against the estate for support. And then there's also a time limit in which you need to bring a claim for either taking under a will as an ex-spouse to a deceased person, or electing to go under the Succession Law Reform Act or an equalization process. And so I'll put a link in the description below to the timelines that you should look out for when you're dealing with somebody who has passed away, because they're very strict and you'd want to follow them. And so with that, I think we'll take a little break and we'll come back and finish it off. And we're back. We went through a lot today, emotionally, legal questions. There's a lot of things that happened to me today, but I'm happy to be back, and I'm happy to be in front of the microphone again. And you know, this is probably one of my more favorite things to do. And in talking to the team behind the scenes, some of the things I said, they were surprised, they learned things. And so it just goes to show you the power and the value of asking those questions, being interactive, sending us those things, because, you know, there's always an opportunity to learn something new. And it's not embarrassing to say, I don't know. And there's questions that came in that I said, I don't know. And I had to go source the information to make sure that I'm not giving wrong information and make sure that I'm not steering people in a bad direction. So always ask questions. These Ask Me Anythings have been inspired by people who want to know more information. That's the purpose of our podcast. The whole reason this was started was to share information with the public and to give back to the community. And we said that at the very outset. And I still maintain that is my goal, as now the host of this podcast. But know that in the future, there won't just be me, so you don't have to listen to 30 minutes of me droning on about things you don't care about, but there are going to be others on the show. And if you do stay tuned and you follow our Instagram, which will be posted again in the links down below, and you follow us on social media on our Facebook page, you can look out for some really cool content that we have in store for you coming up. So with that, I'll leave you. I don't think this is an official season. We're just going to continue on as we have been. And the plan is to have lots more content for you guys to explore and enjoy. You can hear my voice and others and other members of the firm and other guests that we intend to have on the show, which we have a lot of exciting content coming up for you. And with that, I'm Darren Chohan. This is Off the Cuff, and we'll see you next time.